Well, some tough talking there from the Chief Justice D.Y. Chandrachud in the electoral bond matter. Industry body CII, FICCI and ASSOCHAM asking the Supreme Court to defer its order asking for the disclosure of unique serial codes of electoral bonds. Now, the three industry chambers in their plea argued that anonymity is critical for preserving donors' privacy and guarding against adverse reactions from opposing political factions. Ashmit joins us now with more. Ashmit, the three chambers basically saying they have no problem if data related to the donors is disclosed, but they don't want the serial number of the bonds to be disclosed. What's the issue with disclosing the serial number of the bonds? Explain that to us.
Well, to begin with, it's quite interesting that for the very first time in the electoral bond case, it's been argued for a better part of the last 4 to 5 years. For the first time, we have India Inc. actually being represented here, making their voice known. Now, as far as what the concerns are, they've pointed out that while they're comfortable with the idea of having two independent silos of information, one for the donors, the other one for the recipient political parties, they're not comfortable with the alphanumeric serial number that the Supreme Court has directed the SBI to come out with. Now, what is the reason for that concern? Well, at the very outset, we had the benefit of going through their petition. At the very outset, what these industry bodies are arguing is that if this number is shared, it will allow for a direct linkage between those two data sets, which would allow for a very clear indication who are the donors, how much are they contributing, and to which political parties. This is something that they're not comfortable with, that they are seeking to oppose tooth and nail before the apex court. They've cited a few concerns. Number one is that of political vengeance and political retribution. The corporate India is essentially saying that if they donate to a party A, then the party B to whom they're not donating, they are anticipating some damage, they are anticipating some adversity, and that is the chief concern that they've red flagged as a part of their petition. The second they point out is retrospectivity. They point out that the changes that were made to the RP Act, to the Companies Act, allowed for anonymity. Now that the apex court has passed this order, there is a retrospective application back into the period when there was confidentiality, when there was anonymity, and that somehow skews the point in question. The third key point that they have raised is that going forward, there is an urgent need for certainty, for predictability, that such an order by the apex court really is not in keeping with that principle of certainty and predictability. And finally, they go on to say that they've never been heard. The industry bodies have not been heard. Corporate donors have never been heard before the apex court passed this order. So a number of concerns being cited. The apex court today refused to take up their application on an urgent basis. It was filed just this morning. But of course, at a later date, this application will be taken up for hearing. But that's a short window they're looking at. 21st, of course, is the deadline for SBI to come out and furnish the data on serial numbers.
All right, Ashmit, many thanks for joining us. The Supreme Court has imposed